Are you ready for some smart, plain talk on politics, Israel, and the law? It's the Andrew Parker Show. Let's roll. Hello and welcome to the Andrew Parker Show. This is episode 400 and something, as we are on a roll. Yes, indeed. Thank you for joining us. This is a special episode to me, as we are honored to have with us as our special guest G. Barry Anderson, Supreme Court Justice here in the state of Minnesota, now just very recently retired after about 20 years on the Supreme Court, on the bench here in the highest court in the state of Minnesota, and before that on the Court of Appeals for a number of years as well, a graduate from the University of Minnesota. And I will tell you that I have appeared before Justice Anderson a number of times, and there are few better on the bench than Justice Anderson, and many could learn a few things from this great jurist here in Minnesota. Welcome to the Andrew Parker Show.
Delighted to be here, and I want to advise all of our viewers and listeners that I didn't pay anything for that commercial advertisement, and I am now completely retired. It wouldn't do me any good if I did. So I appreciate all the kind words. Some of them might even happen to be true. Who knows?
They definitely are. By the way, go to theandrewparkershow.com, our website, theandrewparkershow.com. Subscribe, follow, do all the other things that social media requires in order that you are very timely in getting each show, each episode as it drops. We have some of the best guests of any podcast anywhere in the country. No exception here today. I last saw Justice Anderson when we were together for the Academy of Certified Trial Lawyers here in the state of Minnesota. Justice Anderson did an outstanding presentation on the issue of the rule of law, and I then was on a panel. It was somewhat of a gunfight at the OK Corral, a panel on the subject of the rule of law with, I don't know, I think it was 4 liberals, and then I was sitting on the end and trying to hold my own, which, frankly, I enjoyed it, and I believe was able to somewhat hold my own. But Justice Anderson's presentation was outstanding, and I thought I would bring back the subject of the rule of law and chat with him more directly about it, and that is what we're going to focus on today. Justice Anderson, I know that you have looked at the rule of law and the issue of what is law in society from a historic perspective. What is your sense of it? And I'll throw in my 2 cents then.
I think we make a mistake when we look at rule of law as codes or collections of rules. Those things are important, and for those of you who have some grasp of some interest in history, we know about ancient codes, Code of Hammurabi, other similar codes that go back, in some cases, it goes all the way back to early Chinese history. We've got fragments that go back more than 2,000 years, and these codes are useful. They contain many interesting provisions. For example, the Code of Hammurabi has a provision in there for if a physician is operating on a patient. Keep in mind that operations in that era are a little bit different than they are today. And the patient is of higher status than the physician, and the patient dies, the penalty is to take off the physician's hand. So I'd like to say that we've improved some since
We've
then.
evolved.
Yeah, we have evolved, yes, and I think it's a good thing. But there are other more common sense kinds of provisions in these codes. They're all useful, but the unique feature of those codes of law is that they are from the top down. In other words, the code is as described, as announced by Hammurabi or whomever, and he or she can change it if they want. And
what about the great American experiment? A little bit different.
yes, and very much so, and it very much keyed to American experience. And one of the interesting things about it is that it, in many respects, bubbles up from the ground up, as opposed to being from the top down. Now, this is not to say that the American legal tradition doesn't draw on the British tradition. It does, and in important ways. But America was a long ways away from England and from Europe, and we had an opportunity to sort of experiment with a variety of different approaches. 13 different colonies, different colonial charters. Some charters very concerned about religious liberty. In a very early way. It was really was unique internationally even. And then other jurisdictions, other colonies and states had official state religions. One of the things that we have this ongoing debate about the First Amendment and what it means in the religion context. But until the 1830s, we had states that had their own official state religions, even though we had the First Amendment from a federal perspective, guaranteeing religious liberty. So there were lots of different things that were going on, and that led to a very serious concern by Americans about what the rule of law looked like, how it was to be handled, and very much a respect for it. The New England town hall tradition and all of that.
Right.
So all of that leads to a very different experience for Americans, and it ultimately culminates in the Declaration of Independence, which I would argue is one of our founding documents. There's legal dispute about that. Justice Scalia, who's somebody whose opinion I take very seriously, was not in the camp that the Declaration of Independence was actually a founding document. He looked instead solely to the Constitution.
Interesting. I did not know that.
Yeah, you can find some public comments from Justice Scalia. Again, not critical of the Declaration of Independence.
Sure.
I want to be clear on that. But he doesn't. He says it is a Declaration of Independence. It's not a founding document. In this, he and Lincoln do not agree. Lincoln very much sees the Declaration as a founding document, and Lincoln talks about all honor to Jefferson, of course, one of the key authors of the Declaration.
So would Scalia say that it didn't have authoritative or precedential impact if you cited the Declaration of Independence?
Well, I don't think he would reject it. I mean, I'm referring to some. I don't know that he ever made these comments in connection with a formal opinion.
Yeah.
But I think he made them in the context that you specify, which is it's not a list of mechanical rules that operates our government.
Right.
I mean, if you want to argue that there are sort of philosophical principles there that are important, I'm sure he wouldn't disagree with that. But in terms of the operation of the government itself, you look to the Constitution.
Very, very interesting. A couple of comments on your comments. First, interesting that you raise the First Amendment and religious liberty in your comments, as just today, the United States Supreme Court ruled 9-0 that Wisconsin violated the First Amendment by denying tax exempt status to the Catholic charities. So the highest court supported the Catholic Charities and its tax exempt status, and rejected the argument of the state of Wisconsin saying that they were not a religious body, the Catholic Charities, and therefore should not have tax exempt status.
One
Interesting
of the things,
decision.
and I didn't reference this in my remarks to the Minnesota Academy of Certified Trial Lawyers. Probably should have. You always think of great things to say once you're done talking. That's kind of how that goes.
Of course.
But one of the interesting things about the American experience that we take for granted, but historically we shouldn't, is that we have very early expressions about the importance of religious liberty that long predate, significant jurisprudence. I'm from a heritage standpoint, I'm sure you're familiar with this, but Washington's letter to the Toru congregation, his declaration, Rhode Island, I believe it is, of religious liberty, and in fact citing Old Testament language as he's endorsing religious liberty. I mean, we would
There's
take
a
that for granted
huge
now.
issue in the founding of this country.
Yeah, no, absolutely.
It's written all over the place.
Yeah, and again, we take it for granted because of our historical tradition, but it was a very remarkable event. Just as Washington's decision to resign his commission and return to Mount Vernon, and later his decision to leave the presidency after 2 terms.
Right.
At least with respect to the former, and I think it might have been respect to the latter. King George III was just astounded that anybody would do this. It was not regarded as normal behavior for the leader of a country to do.
No, this is not a monarchy. No, it is
not. A monarchy. It is not.
And the freedom of expression, freedom of religion, many argue, is now as much as ever under attack. And decisions like that one that came down today, 9-0, fights back against that.
Well, yeah, I think that's right, Andy. But I think it's, I also think it's important we look at this through a longer term lens, so to speak.
Sure.
And that is, we've had these arguments all along, and we've come out differently on some. Utah was not going to be permitted to join the state and to join the union unless they abandoned their Mormon belief in polygamy. You could argue that was a restriction on religious liberty or whatever. But anyway, the point is, there have always been points of conflict on these questions, but ultimately we've come down on the side of religious liberty. You can find lots of examples of these kinds of points of tension on rights guaranteed by the Bill of Rights.
We are talking to Justice Barry Anderson. It is the Andrew Parker Show, and thank you once again for joining us. Justice Anderson, I want to put in my 2 cents on the rule of law. I've thought about this a little bit, and I just jotted down a few notes in terms of what is law, and I am suggesting that it is a statement of or an expression of the rules a society decides to adopt that all are to follow. And many different places are going to adopt different rules that are important to them. In the United States, the foundation of our rules, generally speaking, are a Judeo-Christian foundation. And anyone who suggests otherwise is simply not looking at history. Now, in terms of that statement, that is a statement or an expression of the rules of a society, we have a democracy here, and this is your ground up comments on the open. In other words, our rules and the type of society we want to have is decided by the people, not by the monarchy, not by top down, but by the people. And they do this by electing their representatives who go to the halls of Congress or their state legislature or even their local city council. and they develop the rules that the community intends to live by. But of course, the rules are only as good as their enforcement. And it is the executive branch that, in our construct, our constitutional republic, that is responsible for enforcement. That leads us to a few policy issues that I'd like to discuss. The first is immigration. We have laws on the books, but some have decided not to enforce those laws. And therefore, an inundation of people to our country, irrespective of the laws that were passed by the democratically elected halls of Congress and signed into law by the president, all of them ignored, and millions have come in. Now we're trying to escort them out, deport them. And the argument is now we need to follow the rule of law. Now, if you try to get rid of them who have come here illegally and no enforcement, it is illegal for you to deport them. What are your thoughts on this rule of law issue that is being debated?
Well, first of all, immigration has been a flashpoint for elected officials and elections generally.
Both sides of the aisle, by the way.
Right, correct. And incidentally, going back at least to the time of Lincoln, part of Lincoln's coalition included the Know Nothings, which were an anti-Catholic group, anti-Catholic immigration. Lincoln was a pretty tolerant fellow, and but has encountered some criticism because he wasn't terribly interested in criticizing his part of his 1860 coalition, 1860 and 1864. So the point is
another issue that I didn't know.
Right.
Another reason why I wanted Justice Anderson on the Andrew Parker Show. Yeah, I mean this is great. I didn't know it went back to Lincoln.
Oh yeah. So in the 1840s, 50s, and in the decades that followed, there was a very much an anti-immigrant explosion because there were many immigrants coming into the country, many more today than then, and the tensions that develop as a result of that are obvious. We see them. But certainly met with sort of domestic resistance. And in terms of how we as people deal with immigration issues, we didn't actually have formal immigration rules until I think maybe the 1920s. Well, maybe a little bit before that. But anyway, it's not as ancient a principle as you might expect. And of course, the Native Americans have a view about who are the immigrants here, which is also something I suppose we should mention here. When you talk about rule of law, one of our less successful adventures, to say the least, was the treatment of the Cherokee by Andrew Jackson.
Sure.
In 1830. I don't have any interest in defending.
And he
Jackson.
ignored the Supreme Court.
Yeah, he ignored the Supreme Court. As a matter of sort of technical law, the defendant in that proceeding was actually the state of Georgia, and I think we can criticize Jackson for not being forthcoming and responding. The statement attributed to Jackson, probably apocryphally, although there's some debate about that, is the Supreme Court has made its decision. Now let them enforce it. Whether he actually said that or not isn't clear, but certainly his behavior would suggest that certainly was his viewpoint on that. Yeah. But I want to go back to this question about the political tensions and the issues of government perhaps not enforcing statutes or allegedly disregarding court orders. We get a lot of back and forth on this. We have it in the current administration. We have it in the immediately preceding administration. But there's actually a long tradition of tension between administrations and the courts. the Roosevelt administration, you have the famous court packing episodes,
Sure.
but you also have a famous fireside speech that is delivered as part of the court packing episode. And if you read that speech, I won't bore you with the details here, but I mean, you will see echoes of administrations previous and disputes in the last two administrations with decisions
Sure.
that courts made.
Big disputes. Obama called out the court on a State of the Union. And,
Right.
long ago, Abe Lincoln, didn't he suspend writ of habeas corpus and he ignored the court? What was it, the Taney Court?
Yeah. So, in fact, Roger Taney says to then sitting as a circuit court justice, kind of a weird procedure that for all of our viewers here, if we had 2 or 3 hours, Andy and I would do a deep dive on all these details about the writ of habeas corpus and the procedural posture. We won't do that to you. We'll just note that there was this dispute about Lincoln did suspend habeas corpus, and it was sometime later that Congress actually gave him that authority. So a little complicated, but the point is these disputes are nothing new, and we've had them before. We're going to have them again. One of the interesting things about the Obama remarks,
and it's not a constitutional crisis,
right?
I mean, people are waving. They're saying, "Oh my God."
So Obama makes the comment, and I think I'm not certain of this, but I think you can go back and I think you will find, if not members of the Roosevelt administration, certainly some members of the press and other places, but we've heard some complaining from the Trump administration and spokesman for the Trump administration about unelected judges making decisions, because of course federal judges, once appointed by the president, confirmed by the Senate, serve for life. They're not elected. That thought has occurred to previous presidents. If you go back and look at Obama's remarks, you will see President Obama, making a remark about unelected judges and a majority of the people, frustrating the will of the majority of the people. You'll find similar remarks, as I say, going back to the Roosevelt administration, or at least those defending. Anyway, so the point is, the rhetoric that we're hearing today, regardless of how you stand, and you heard it from Biden with respect to student loans and unelected judges and things like this. It's not new. We've had it before.
And now, a word from our sponsors. A record of success second to none. Parker Daniels Keyboard Law Firm, the numbers tell the story. The last 5 cases our lawyers have brought to trial have resulted in million and multi-million-dollar verdicts for our plaintiff clients and 0 defense verdicts for our defense clients. Put simply, we try cases and we win cases. Hi, I'm Andrew Parker. At Parker Daniels Keyboard, we take our work personally and we go the extra mile. That is why some of the biggest law firms, locally and nationally, send cases to us to handle when they can't. If you have a challenging and critically important business or personal legal dispute that must be favorably resolved, whether regarding a contract matter, a business divorce, a real estate dispute, an employment dispute, a civil rights or defamation matter, plain talk, if it's a big deal, contact us at Parker Daniels Keyboard. Wise counsel, winning results. Go to parkerdk.com. If you're considering options for a 1031 exchange, True North recommends checking out Walton Global. They're a land investment company with over 46 years of experience and a very impressive track record. Their clients are some of America's largest home builders, and True North recommends them highly. You can visit True North's website to get more information at investtruenorth.com or call at 619-455-0275. That's 619-455-0275. When it comes to immigration law and the fact that there's no enforcement of our laws, democratically elected legislators established those laws. They were signed into law here, years ago and more recently, although not so recently because there's been no agreement on immigration law or the changes, uh, and they're ignored. But then many are pounding the table that you've got to follow the law, and they're interpreting it to their own benefit. Of course, there's a big dispute about whether due process laws apply to illegals who are here in the United States, and that is simply a dispute. I don't know that we need to talk about it on this show, but another example of a lack of enforcement is what occurred in the summer of 2020 with the George Floyd murder and what followed. Billions of dollars of damage across the country, a lot of it here in the state of Minnesota. People killed, people dying, and very little enforcement of this clear criminal action and violation. We now see anti-Semitism on campus, and whether or not there's going to be enforcement of the laws as it relates to that. So the rule of law, uh, really, it's easy to say, well, this administration is ignoring the rule of law. They're destroying our democracy, et cetera. But usually what it comes down to is that's nothing more than a political statement.
Well, and I want to say on the immigration question, there are a lot of sort of arguments that run both ways on this question, and there are, of course, also some executive power and judicial power collisions here, which we've talked about previously. And I'm not taking a position on who's right or wrong on any particular immigration question here. But what I am saying is, I think it's really helpful if we have a longer perspective on this than the last 6 months. Even if, you're very critical. I'm not speaking you personally, but others. Others are
Yes.
very critical of the current administration, or they're very critical of the administration that preceded it. It is really helpful to have that longer lens. And one of the issues when we talk about challenges to the rule of law, we always want to focus on the immediate crisis, but I think a much more significant problem is what I call the collapse of civic education, historical education, and we have now at least a couple of generations of students who probably have not had the benefit they should have had from a strong dose of American history and civic knowledge. One of the issues,
Huge problem.
yeah. Well, if you look at polling data, and it's pretty. You look at the National Association of Economic Progress, or Educational Progress. I'm sorry, economic progress is a different issue. National Association, the NAEP test, NAAP test, and what you find is basically somewhere between 15 and 20% of students are proficient in American history and civic education. That number's too low, and that's a problem.
And we're seeing it on campuses with these people protesting something they know nothing about and can't answer a question about.
75% of Americans cannot name the three branches of government.
No, it's unbelievable.
So this is a significant. And you see it in other. If you ask the public, how should we balance the federal budget? Well, let's cut foreign aid. Foreign aid, depending on who you do the arithmetic, is between 0.5% and 1% of the federal budget.
Right.
Good luck with that.
Right.
Anyway.
No, exactly. And I have lobbied on Capitol Hill in Washington every year for nearly 30 years on the issue of foreign aid and reminding our members of Congress that foreign aid is about 0.5% to 1%, and much of it is spent back here in the United States,
right,
driving our own economy. And depending on who the foreign aid is going to, it is providing many other great benefits to the U.S., particularly foreign aid to the state of Israel, a topic that we talk about on the Andrew Parker Show often. That is the state of Israel. By the way, just got back from Israel, and we're going to drop an episode here soon about
Can I
my trip.
mention, Andy? Can I mention two things? Well, I
Yes.
mentioned one of them already, civic education. I want to mention a second thing that I think is a significant challenge to the rule of law. And
Mm-hmm.
these are things that you're not reading about in the newspaper. Well, you are a little bit because of the trade debate, but I think these are significant challenges, much more significant than some of the back and forth between the branches that we've been hearing about over the last several years. And that is the administrative branch of government,
Yes.
the so-called fourth branch of government. Of course,
The
there is no
deep
such thing.
state.
Yeah, well, yeah, the deep state, right? Exactly. So setting aside the deep state, but one of the questions one of the sort of trick questions I give to students when I have a chance to visit with them, I tell them, can you tell me how many federal crimes has Congress created? And you get various guesses, and then they'll say, well, what's the answer? And I said, the answer is nobody knows. In fact, the George Mason University and Heritage Foundation, doing one of these fancy computer algorithms. Our lives are run by algorithms, right? I don't know what an algorithm is, but anyway, they had one of these fancy algorithms, and they came up with about 5,200 crimes, mostly by looking for words that you and I as lawyers would look for, like it is a crime or punishable by, etc. Looking for keys that would tip. So we've got an estimate of 5,200, but that's not all of the potential federal crimes, because we have the Code of Federal Regulations, which now exceeds 175,000 pages,
Yeah, it's unbelievable.
and
It's
buried
exponentially growing. The
right,
bloat is just outrageous. And
right.
people don't get that. They think, oh, this is a good thing. We've got a federal government. They're taking care of us. No, it's a bloat that increases government failure. It does not provide what is intended. Oftentimes, we have unintended consequences.
No, the problem that you run into is that I think for a rule of law to have credibility, it has to be known and understood, and you can't say that crimes or just rules buried in 175,000 pages are known or understood, and so it is a real threat to the credibility of the court
And the other point is these are
of law.
unelecteds who often create these rules. And yes, there are legal principles that allow them to work within, but where those lines are drawn, and they are changing, the Chevron case obviously
Mm-hmm.
has now been shifted and changed by the most recent court. Uh, so it's a
Here's a
threat.
real life example of this, Andy. In 1866, Minnesota published all of the laws of the state of Minnesota in a single volume. Today, and of course, a lot of this is computerized, it's Westlaw, etc. But you're looking at 30 volumes of statutes and 30 volumes of rules. So even if you just set aside the feds and say we're not going to talk about federal rules, Minnesota has a similar problem. And that problem is replicated in 49 other states. It's not just us.
And it's exponential when you get to the federal level. Justice Anderson, while I have you, and it's really been an honor to have you with us on the show, uh, there just are not that many people that have the opportunity during their lifetime to sit on the highest court, either of their state or at the federal level, and to see behind the curtain, as it were. What can you share with us about having sat on the Minnesota Supreme Court for nearly 20 years in terms of how the court really works, how it operates?
Well, my observation about this is that so I had the privilege of serving. I was Governor Carlson's last appointment to the Court of Appeals. Joe Hulbrooks and I basically were appointed at the same time.
Mm-hmm.
And I was Governor Tim Pawlenty's first appointment to the Minnesota Supreme Court. And so that was a very long time ago.
I've always said Pawlenty is brilliant.
Yes, well, I'm always grateful that he saw fit to appoint me. Whether that was one of his brilliant moves or not, we'll leave to others to decide. Maybe there's a dissenting opinion about that. So I had a chance to sit on a court, different courts that had different compositions based on appointments from Governor Carlson, Governor Pawlenty, Governor Dayton, Governor Walz,
Ventura.
And Governor Ventura, exactly, who appointed both, and thank you for reminding that, both Sam Hansen and Helen Meyer.
Mm-hmm.
And what I would tell people is, in all that time, I never went into a conference room with a member of the court and the discussion centered around who appointed them or what their sort of political philosophy was,
Mm-hmm.
or who they preferred to vote for president or governor or mayor, for that matter. And while there might be differences on the court that develop over time based on sort of judicial philosophy and things like that, I mean, some of us may have been more inclined to look to sort of the original public meaning of documents and things
Mm-hmm.
of that sort. But even there, I think you have to be careful because there aren't lots of clear lines, and in fact, there was lots of conversation about how to interpret statutes and our state constitution and so forth. None of that was political. I worry that we live in an environment now where a discussion about decisions that courts make, it includes, every time and it's been true in this administration, it was true in the last administration, it's become very common. Well, Justice X or Judge X was appointed by this
Yes.
president or that president. This is really dangerous territory. Is it a relevant fact? Should you be allowed to say it? Of course. First Amendment, you have the right to do so. People draw their own conclusions. But I caution lawyers, you may be unhappy with particular courts or particular rulings, and I think it's fine to criticize them, but I don't think we should feed this. And so I encourage particularly young lawyers or students, law school students, and so forth. You can be a role model on some of this in a way in which, you and I both have stories to tell, I'm sure, from our time early in the practice of law, where you had a case that didn't go right, and the results were not satisfactory to the client, and you watched this handled by senior members of the bar, done well and sometimes done poorly. But when it's done well, it's Judge X is wrong about this. We're going to take this up on appeal, but here's why he or she reached this decision. And we need to be prepared to respond to these issues on appeal because that's why we're in the hole we're in. And I think that lawyers are uniquely well positioned to make this pitch. You don't forfeit your right to criticize loudly and thoroughly decisions from judges. It's wrong, and you can tell us why it's wrong, but you do it in a respectful way, recognizing that, at least in theory, we're all attempting to apply the same rules. I think about the Supremacy Clause. We started this conversation talking a little bit about the founding era. Maybe it's a good place to finish it. Let's talk about, for just a couple of minutes, about the Supremacy Clause of the Constitution.
Yes.
Yeah, our listeners, our viewers now are going, oh gosh, what is this all about? Well, anyway, There's a provision in the United States Constitution that says the Constitution is the supreme law of the land. Now, we take that for granted. It's in the water. We've had it. We grew up with it. We've had it for more than 200 years. But think back to 1787 and 1788, and Adams and Jefferson and all of the founders. Hamilton of New York, Jefferson of Virginia. I mean, their loyalty is to their state, and yet they're signing off on a document that says, not anymore. It's this federal constitution that is the supreme law of the land. That is a remarkable event in legal history.
Yeah.
And we don't appreciate it as much as we should. And I think that this is one of the things that I would encourage lawyers to try to recapture if we can do it. It'd be nice to be able to train the media, but I've given up on that. So I think we're stuck with, and of course, we talk about how the media is, has biases or whatever. Well, go back and look what Jefferson, what the media that favored Jefferson, what the media favored Adams were saying in that 1800 race. And you'll say to yourself, okay, maybe it's not as bad as I thought it was.
Thomas Paine.
Yes. Yeah, exactly. Well, you see, now you've mentioned another topic, but there's a great book called The Great Debate by Yuval Levin, who's sort of a philosopher type, and it's about Edmund Burke defending sort of the American approach, and Thomas Paine, who was very much a fan of the French Revolution.
Yes.
And as we all know, the French Revolution didn't go very well.
No.
So I think Burke was right, Paine was wrong. But anyway, enough.
Well, that's another conservative liberal battle between those two, certainly, no question, way back then. And we thank you very much, Justice Barry Anderson, for joining us on the Andrew Parker Show. This has been a fascinating discussion, a great discussion, which, Barry, you and I have all the time when we are together. I still refer to you generally as Justice Anderson, as that is what I have gotten used to, and one of the great jurists, one of the great members of our bench here in Minnesota, and frankly, anywhere. Thank you so much for joining us. Everyone go to the AndrewParkerShow.com, subscribe, take down the number. You'll see it right there, 952-522-2818. Text us any of your questions on the issues of the day. We're going to be having a show regarding a debrief, really, of my trip to Israel. I've been to Israel probably 20 times. This trip was amongst, if not the best trip to Israel that I've ever had. So there's some fascinating things to share, and what a magnificent country it is. I felt not only safe, but so welcome there in the state of Israel. It really is something we should all be proud of here in the United States, to be such a close ally with the state of Israel. Barry Anderson, thank you very much. And for everyone out there, be kind to your neighbor. For more Smart Plain Talk, go to theandrewparkershow.com. Learn about all of your listening and viewing options. And remember, all the great things are simple, and many can be expressed in a single word: freedom, justice, honor, duty, mercy, hope. This episode of The Andrew Parker Show is sponsored by Parker Daniels Keyboard and True North Private Investments.
Did your employer make you sign a promissory note when joining the company, and now you want to leave, but you're afraid your firm will pursue you personally for that debt? This is Jesse Keyboard from the law firm Parker Daniels Keyboard. I recently represented a client who had signed such a note, and I was able to get them out of their $500,000 debt to their company, which allowed them the freedom to exit a bad employment situation and enter a much better one. Meeting our clients' objectives is our focus at Parker Daniels Keyboard, and in this regard, we win. Our experienced trial team of lawyers at Parker Daniels Keyboard have secured major victories in state and federal courts across the country and through arbitration. We have the legal expertise in all types of business disputes, labor and employment matters, real estate matters, shareholder disputes, financial transactions, security issues, and appeals. For wise counsel, winning results, contact us at Parker Daniels Keyboard, a premier litigation law firm that provides efficient, aggressive, and innovative solutions to complex legal problems. Wise counsel, winning results. else. Go to parkerdk.com.
Are you a high-income earner or a business owner looking to secure your financial future? At True North Private Investments, they focus on helping you break free from the limitations of traditional investments. Diversify your portfolio with private equity, real estate, and credit opportunities built to thrive in any market condition. Plus, their tailored tax strategies are designed to help you keep more of what you've earned. Your success deserves a smarter approach. Choose True North to grow, protect, and optimize your wealth. Call them today at 619-455-0275 or visit investtruenorth.com.